Well, recent court rulings from Kansas illustrate the diverse ways the law is involved in ag-related activities. Now, two of the cases involve ag real estate. One of those were having estate planning implications. Now, Roger McEowen with the Washburn School of Law joins us with some insight. And Roger, thank you as always for being here. First case that we're going to look at focuses on an irrigation system included in land valuation. Give us a little bit of overview.
Yeah, this is a situation where I've preached this for 30 years to people. Don't do this. Don't leave your farm property, your legacy, your land to your kids in co-equal ownership, co-equal undivided ownership. And that's what happened in this situation. You've got a bunch of farmland in Kansas. It goes to three sons in equal undivided interests in 1/3. One of the boys dies, and so you now have two brothers and a sister-in-law. And the sister-in-law wants her third share out of this. And so what happens is she files a partition action in this situation. Well, one of the other brothers had paid over $83,000 to put a 10-tier irrigation system on some of the dry land to make it irrigated land. And now you just increased the value of that land significantly because now it's more productive. And the question before the court is she entitled to a 1/3 value of now what is the enhanced value, even though she didn't contribute anything to the irrigation equipment purchase?
So what was the outcome of the case? And obviously there is a big lesson to keep in mind here for estate planning.
Yeah, they enhanced the value significantly, and she shares in that third. And so she said, I want to take some of the dry land, which was not worth, comparatively, wasn't worth nearly what the irrigated land was. And so they had to make a cash payment to her to balance things out. Again, don't leave your property to your kids in co-equal undivided ownership. Use some form of entity and then give stock interest that way, or partnership interest. And you have a buy-sell agreement so that they get bought out, so that you keep the farming operation in the hands of the heirs that want to farm, and you get cash in the hands of the non-farm heir. This is just a bad way to do things.
So another case focuses on a landowner who established adverse possession through tacking. Talk about what's involved here.
Yeah, this is actually a question I get several times a year, and that is many people are familiar with the ancient concept known as squatter rights that came from England several centuries ago. That ended up in United States law and known as adverse possession or boundary by acquiescence. And we see this in ag all the time. And that is where I may farm up to a particular line that I believe is the boundary, and my neighbor does the same, and we just do that for many years, or we treat an existing fence as the boundary, and lo and behold, maybe the land changes hands and somebody has a survey done, that new owner has it done, and that actual surveyed line is over on my neighbor further, and so I can, or it's over on me, either way, but there's a disputed strip. And one party will file what's known as a quiet title action to get title ownership of that disputed strip.
There's a 15-year requirement for adverse possession. Is there a reset when there's a change in ownership here?
Well, in Kansas, it's 15 years. That's not 15 in every state. In some states, it may be 5, it may be 2, it may be 21, it may be 10. It's all over the board. So you have to pay attention to your state statute. But in this case, you had a landowner that owned the land for 7 years. A prior owner had owned it for 8 years. But if that use of that particular line or fence has been consistent for whatever the statutory time frame is, here 15, then the court will allow you to tack on your prior owner's usage to yours, and you would be deemed to meet the 15-year statutory requirement, and you can have then title quieted in you to that disputed area. So boundary disputes, fence disputes are pretty common in ag, and it's good to know the rules.
Yeah, obviously, so important, such great information, or maybe just call Roger and have him help you with all of it, right? Roger McEowen with the Washburn School of Law, always a pleasure to have you join us. Thanks for being here.